5 things every prenup should actually include. Most people get this wrong. Everyone has an opinion about prenups. Some people think they're unromantic. Some people think they're only for the ultra-wealthy. And some people have them, but have no idea if they actually cover what matters. Today, I want to cut through all of that and talk about something almost nobody explains clearly. What a prenup should actually say if you want it to protect you. Welcome to Fuel Your Wealth. This is not legal advice. What I am going to share are the financial and legal elements that experts and attorneys commonly recommend you address in a prenuptial agreement. Elements that often get overlooked or poorly written and end up being unenforceable or inadequate when you actually need them. Let me start with the most important thing to understand about prenups. A prenuptial agreement is only as good as what it actually says. Vague language, missing categories, and unclear definitions are how prenups fail. Judges have thrown out entire agreements because they were too general or failed to address key areas. So, if you are going to have one, it needs to be specific. Here are the 5 things financial and legal experts consistently say should be in every prenup. Number 1. A clear definition of separate property, everything you own before marriage. This sounds obvious, but it is where most prenups are either vague or completely missing detail. Your separate property is everything you owned before the marriage. Real estate, investments, business interests, retirement accounts, savings, personal property. In community property states like California, anything you earn or acquire during the marriage is automatically considered jointly owned. A prenup can change that, but only if it clearly and specifically defines what your separate property is at the time of marriage. The standard that attorneys recommend: attach a schedule, an actual list of your significant assets at the time of signing. Account balances, property addresses, business ownership percentages. Vague language like "my premarital assets remain mine" is not enough in many courts. Specificity is protection. Number 2. Business ownership and future business equity. If you own a business, or if there is any chance you will start one during the marriage, this needs to be explicitly addressed. Without clear language, a spouse can potentially claim an interest in a business you started before the marriage if marital funds or time were contributed to it during the marriage. This is one of the most contested areas in high-asset divorces. What a good prenup says here: who owns the business, what percentage, and how any appreciation in value during the marriage is treated. Some couples agree that the business stays with the founder, but agree to a specific formula for calculating any marital contribution. The formula matters, vague language does not. Number 3. How inheritance and gifts are treated. Most people assume that if they inherit money or receive a gift, it stays theirs in a divorce. That assumption is often correct, but it can become complicated in community property states if the inheritance gets commingled with joint accounts or used for joint expenses. A prenup can clarify that any inheritance either spouse receives, both during and after the marriage, remains that spouse's separate property, regardless of how it is held or used. This is a simple clause, but one that many standard prenups leave out. Number 4. Debt allocation. Who owns what liabilities? Most prenup conversations focus on assets, but debt can be just as important. What happens to student loans one spouse brought into the marriage? What if one spouse has existing credit card debt or a business loan? In some states, spouses can become responsible for each other's premarital debts, depending on how those debts are managed during the marriage. A well-drafted prenup explicitly addresses premarital debts: who owes them, who is responsible for paying them, and what happens if the other spouse's income is used to service them during the marriage. It also addresses what happens with joint debts incurred during the marriage if the marriage ends. Number 5. A review or sunset clause. This one surprises people. A sunset clause is a provision that says the prenup expires or gets renegotiated after a certain number of years. Some states automatically limit the enforceability of prenups over time. More importantly, a prenup that made sense when you were 28, with one business and no children, may not make sense at 45 with 3 businesses, real estate, and a complex estate plan. Financial and legal experts frequently recommend building in a mandatory review period, typically every 5 to 10 years, where both parties revisit the agreement with updated financials and ideally an updated signed amendment. This keeps the prenup current and significantly reduces the likelihood that it will be challenged for being unfair at the time of any dispute. One important note that cannot be overstated: a prenup must be drafted by a qualified family law attorney, ideally with both parties having separate legal representation. An agreement that was not properly disclosed, that was signed under duress, that had no independent counsel, or that was signed too close to the wedding date has a much higher likelihood of being thrown out entirely by a court. Protect yourself by doing it right. Don't forget to like this video and subscribe to Fuel Your Wealth for more videos like this every week. This is not legal advice. Prenuptial agreements are legal documents that must be drafted by a licensed attorney in your state. Always consult a qualified family law attorney before signing or creating any legal agreement.